Jonathan Anakiza, both fixed the police of the regular works of prosecution while the person Ate Giovanni Baroya and Sarah on Facebook. And on watching brief, we had on behalf of families and children, we had Mr. Stanley Okecho, Mr. Roger Mugali, and Mr. Pius Katumba Busogozi from James Advocates. And I know that all parts of the person and the prosecution made oral submission in terms of fraud, the case, and made I have always spoken on the right of what I find to be the prosecution case. Project is run by Ggaba Community Church, operated at Ggaba located at the Ggaba Trading Zone, Ggaba Parish. From the facts of the case and laid before this court, One year and 3 months were under the care of Ggaba Early Childhood Development Center, and in this case I will keep referring to it as the facility and as
Oluto lwabi lwaleeta obujulizi okulaga nti abaana bano abaana asooka etteku yali wa myaka 2.6, owokubiri Keisha yali wa mwaka gumu n'emyezi 11, owokusatu Seryange yali wa myaka 2.4, asembayo Odekerayan yali wa mwaka gumu n'emyezi 3, nga bonna baali mu ssomero erya Ggaba Childhood Development Center, ate ajja kusigala nga akisoma nga center, ate nga essomero lino liri wansi wa church eya Ggaba Community Church nga yesangibwa Ggaba mu Machije Division, Kampala District.
Keisha Abenero was female and the 3 deceased persons were male. The other 2 were male. And the center was founded by Ggaba Community Church and operates a daycare and an early childhood program for the vulnerable and malnourished children who are outside from the community. The children under the daycare program pay some money, while those ones, the vulnerable, do not pay. Ignitia Selyange, Gideon and Teku were among the vulnerable, while Odekerayan and Keisha again or team were under the daycare program.
Keisha yali mwana muwala, abalala baali balenzi, nga bonna essomero lino lyali wansi wa church eya Ggaba Community Church, ate nga baali balina daycare ate n'okutuumirawo abaana abaali batalina mwansirizo, nga babajjanga mu bantu ne babalabirira, ate nga bagamba baali mu daycare baali basasula, ate be bajjanga mu bantu nga tebasasula.
Christopher Okelo Nyum, who I will keep referring to as the accused person going forward, he is a male adult, an American citizen by nationality and Ugandan by birth. He holds 2 American passports, and those passports were admitted in court as exhibits.
Omuwawalirwa bamuyita Christopher Okelo Nyum, era tujja kusigala nga tumuyita muwawalirwa nga musajja mukulu mutuuze wa America naye nga bamuzalira mu Uganda alina passport bbiri nga za America ate zonna bazireeta mu receipt.
On 31st March 2026, the accused person hired a motor vehicle RAV4 for self-drive. On Wednesday, 2026, the person drove from Ggaba Cross, Chandra, where he was residing, to the center, where he met one of the caretakers in Speedy Namtedi, who testified as PW6.
Ennaku z'omwezi 31 ogwokusatu 2026 muwalirwa yapangisa emmotoka kika kya RAV4 ng'agenda gyevugira era nga
She is kind of a big deal, and no, it's not about her big office. Thanks to her big connection that keeps her big business always on. You too can be a big deal when you keep your business always on. Enjoy monthly payments, zero interruptions, predictable billing, and best-in-class coverage without daily recharges. Stay on always with Airtel Business Postpaid. Call 125 or email business.support@ug.airtel.com to sign up. Airtel, regulated by the Ghana Communications Commission.
Years and required an admission for her.
okutuusa Phoebe bwe yagenda n'amubuuza oba asobola okumuyamba, bwe yamubuuza n'amuddamu nti yali alina omwana w'emyaka 3 yali ayagala kumuyingiza essomero era n'amubuulira biki byali byetaagisa kwe kugamba nti agenda kugenda yeetegeke akomewo.
The next day, the 2nd of April 2026, at about 11 a.m., the accused person returned to the center, and when Namtedi saw him, she went to the gate, and the accused person informed her that he had returned to make the payments as he had promised the previous day. PW6 opened the gate for the accused person and brought him to the office of the coordinator of the center, known as Miss Annette Odong Agoye, who testified as PW7.
Ntenga bbiri ogw'omusanvu bbiri ogw'okuna bbiri abiri mu mukaaga ssaawa nga 5 ez'okumakya omuwalirwa yakomawo n'atuuka ku geeti. Phoebe n'amulaba, bwe yamulaba n'amugamba nti yali azze kusasula era n'amugulirawo geeti n'amutwala mu ofiisi yali akolera ssente eyo gwe bayita Annette Odong era yajja wano kw'obujulizi ng'omujulizi w'omusanvu ku luudo olwali.
Miss Namtedi introduced the accused to Miss Annette and informed her of their encounter and conversation the previous day. Miss Odong welcomed him and also interviewed him pertaining to the details of the child being enrolled. The accused person inquired about the requirements and he was informed that he needed to pay a total of Uganda shillings 190,000, which would cover the registration, daycare fees and uniform.
Phoebe yayanjulira omuwalirwa n'amuwanjulira Annette n'amugamba nti baali boogedde ejjo era n'amwaniriza n'amubuuza ebikwata ku mwana kwe yali aleeta era namala n'amubuulira biki bye yali byetaagisa n'amugamba nti yali alina okusasula emitwalo 19 nga giriko egy'okumuwandiisa omwana kuliko ejjaddeeke n'eza uniform.
The accused person who said he had no cash on him asked whether he could pay using mobile money, and he did so on the telephone number of Miss Annette.
Nti yagamba yali tatambudde n'esente nkalu n'asaba nti sente aziteeke ku mobile money era n'aziteeka ku mobile money ya Annette.
PW7, that is Annette, asked PW6 to issue the accused person with a receipt, and the same was issued to him, and it was receipt number 2958 in the name of Zuyer Onyum.
Nti Annette okusaba Phoebe ng'amuwandiikira risiiti era n'awandiika risiiti ng'eriwa mu mannya ga Zuyer Onyum.
The accused then left the office promising to return with the child and the mother on Tuesday the following week, and I take notice that this was the week of Easter and the next working day was Tuesday of the following week.
nti era yavaawo n'abasuubiza nti agenda kujja n'omwana ne maama w'omwana ewiiki eddako olwokubiri era ekitiibwa Namutarazi nti yali wiiki ya Easter n'olwekyo olunaku olw'olwokkola lwali lwakubiri.
The accused person then walked out heading towards the gate as Miss Namuteri, who was still in the office of Miss Annette, bent down to keep the receipt booklet in the drawer.
Era yatambula n'adda ku geeti Namuteri yali asigadde mu ofiisi ng'ate ateeka receipt mu drawer.
At that time, some children were in the compound playing, and as Miss Namuteri rose up to look towards the gate so as to go and open for the accused person to exit the center, she saw the accused person bending while holding a child, and she thought that he was beating the child. She ran outside to establish why he was beating the child, only to reach there and find that the accused person who was holding the knife had already cut the neck of one child, and this child was Keisha.
Nti bwe yabadde afuluma abaana abamu baali wabweru nga bazannya nti era Feddi bwe yagenda okusituka ng'agamba agenda aggulewo geeti omuwangirwa afulume n'atunula omudinisa n'alaba ng'omuwangirwa akuttamye ng'akuta omwana n'asooka n'akubuuza nti oli yali akuba omwana n'adduka kumubuuza lwaki yali akuba omwana n'asanga nga yali aneekambe ng'amaze okusala Keisha.
And she was lying in a pool of blood. And the accused person at that time was reaching out for another child.
Yali musala ky'omusaayi ate omuwangirwa yali agenda ku mwana omulala.
Miss Phoebe asked the accused person why he was cutting the children, and she also threw one of the children's bicycles, which were in the compound, at him to scare him off. The accused person left the child and ran after her, threatening to cut her as well.
Fiddi bwe yamubuuza lwaki yali asala abaana n'amukanyira n'akagaali abaana ke bali bazanyisa n'asooka n'akaleka n'amugoba n'adduka.
Miss Phoebe ran away from the accused person while making an alarm, but she fell down, and the accused person ran back to the children very fast. And by the time Miss Phoebe returned to prevent or stop him from cutting the children, she found when he had cut the second child, and she again threw a bicycle at him as he was pursuing the third child.
Nti bwe yamugoba oli n'adduka ng'akuba emiranga ng'omumwagwa bw'omala okugwa ono n'addayo mangu n'adda ku baana n'akwata omwana owokubiri n'amusala.
The accused person again ran after Miss Phoebe, and when she fell down, he drew the knife, threatening to cut her as well.
Nti era n'amukanyigira akabugaali akalala bwe yakamuganyigira oli n'addamu n'amugoba n'adduka era yagenda okulaba ng'akuta omwana omulala.
The accused person then left Miss Phoebe and went back to the children, and when she rose up, she found him cutting the last child, and the last child to be cut was Odeke Ryan.
Nti era yamala n'amuleka oli bwe yagwa n'agenda okusituka n'asanga ng'asaza omwana owasembayo ate yali asembayo bali bamuyita Odeke Ryan.
At that time, Miss Annette, who also witnessed the cutting of some of the children together with other caretakers, were making alarms which attracted one Cyrus from Kenya, who arrested the accused person. He was joined by Moses, the security guard, Bashir, and Timothy. When he was being arrested, the accused person threw the knife over the chain link fence. The accused was immediately locked up in the guardhouse at the gate to keep him away from the angry crowd which had formed at that time. And upon his arrest, the accused person was found with 2 new knives in his socks, and they were recovered from him.
Nti Annette naye yali alabye nga asala abaana abamu ne keyateeka omulala eyaliwo bakuba embeeru era bwe bakuba embeeru Cyrus Bukenya, Moses eyali omukuumi, Bashir ne Timothy bajja bwe bamala okujja oli n'abanga n'asuula akambe n'akasula wabweru wa geeti era ne bamukwata ne bamugayira mu kayumba ak'obukuumi nga bamutaasa abantu abaali batandise okujja era bwe bamukwata ne basanga nga yali alina bwambe bibiri bipya mu sitookingize.
3 of the attacked children, namely Eteku Gideon, Kisha Ageno Roth, Tim, and Ignitia Seryange were rushed to Wenzi Medical Center, which is about 300 meters away from the center, hoping to save their lives. However, they were pronounced dead on arrival.
Abana abasatu Eteku, Keisha ne Seryange babatwala ku ddwaliro lya Wenzi Medical Center nga balowooza bayinza okubataasa naye bwe baatuuka ne bagamba nti bali bafudde.
Rano Deke, who was clearly dead, was left at the veranda but was also later taken to Wenzi Medical Center by police.
Ryan Odeke eyali asigadde naye nga yali akabalaza naye oluvannyuma naye baamutwala ku ddwaliro lya Wenzi.
The dead bodies of the 4 children were then taken to Mulago, Kampala Capital City Mortuary by police, and post-mortem examinations were done on them by Dr. Katongole Abdul, who described the injuries on all the bodies of the 4 children to have been on the necks, and concluded that the cause of death for the 4 children was deep cut injuries to the neck.
Nti emirambo gino oluvannyuma bagitwala e Mulago mu ggwanika era omusawo gwe bayita Akatongole n'akebera emirambo n'alinnyonnyola nti bonna baali balina obuvunne mu bulago ate n'agamba tekyabaviirako okufa baabafumita nnyo ne bavaamu omusaayi mungi.
The police officers from Kabalagala Divisional Police visited the center, which they termed as the primary scene of crime, and recovered the killer knife and the 2 other knives and a backpack which was also recovered on the accused person, picked some suspected blood from the compound, among others.
Abasirikale ba poliisi e Kabalagala bagenda mu kifo ekyo we bakiraba ne baggyayo obwambe bwe basangawo ne baggyayo n'ensawo omuwangulwa gye yali alina naye ne batwalako n'omusaayi gwali mu luggya.
The samples recovered were subjected to DNA analysis and the report was admitted in evidence.
Nti omusaayi ogwo bagutwala ne bagukebera era ebyava mu kukebera babireeta ng'obujulizi.
The police officers also removed the accused person from the guardhouse at the center amidst the angry crowd which desired to lynch him, and they took him to Kabalagala police station.
Omuwawaabirwa baamugya mu kayumba k'omukuumi era ne bamukuuma abantu abaali batuuse awo nga bagala kumutta ne bamutwala ku poliisi e Kabalagala.
On 3rd April 2026, the accused person led the investigating team to his house, which he had rented in Kanja at Namugera Close, Katumba Zone. A search was conducted in the accused's house, and a number of items were recovered, which included electronic devices, 2 laptops, 2 mobile phones, and 3 hard drives, which were subjected to forensic analysis, and a digital analysis report was also admitted as evidence.
Ngasatu ogwokuna 2026 omuwawaabirwa yakulemberamu abaali banoonyereza omusango guno n'abatwala mu nnyumba ye gye yali apangisa ekyanja era bwe baayingira ennyumba ne bajjaza bajjamu ebintu nga laptop 2, amasimu n'ebintu ebirala.
The other items recovered were 2 American passports, a driver's license from the state of Virginia, a sanity report dated 30th December 2025, and 5 new knives, among others.
Nti ebintu ebirala bye bajjamu passports 2 ez'Amerika, bajjamu driving permit, ne bajjamu obwambe 5, ne bajjamu ne report gye bali bamuwandiikidde okuva mu ddwaliro nga bagamba omutwe gwe gwali gukola bulungi.
The accused was examined on police form 24 by Dr. Emmanuel Nwamanya, who testified as PW11, and he was found to be mentally normal. It was upon that background that the accused was indicted for murder in 4 counts, hence this case.
Nti omuwawaabirwa bamutwala ne bamukebera ate yamukebera yali musawo gwe bayita Emmanuel Nwamanya era yajjanga omujulizi w'oludda olwali ow'okumi oluvannyuma ne bamuteekako emisango 4 gya butemu.
The accused person gave an unsworn statement and called 2 witnesses in his defense. he had mentioned 4 witnesses but provided only the telephone numbers but without any physical address. Only 2 witnesses were reached using the telephone numbers provided by the accused person, and efforts to trace the 2 were futile because the phone numbers were not on.
Nti omuwaabulo yayogera nga talayidde era n'aleeta abajulizi babiri. Yali asabye okuleeta abajulizi 4 naye nga tataddeeko wa gye bali babeera, n'ateekako amasimu gaabwe gokka. Okukuba amasimu ababiri ne basobola okujja, ababiri amasimu gaabwe gali tegaliiko.
It is important to note here that one of the 2 numbers that he had provided that could not be reached was an American number.
Naye tulina okumanya nti mu masimu ago abiri emu yali ya America.
In his defense, the accused person did not deny killing the 4 children, but stated that he did not act intentionally or deliberately.
Mukuwozaako teyagaana nti omusango teyagukola, wabula yagamba nti teyagukola mu bugenderere.
He stated that although there were claims that he was completely mentally okay, there may have been other mental challenges that may have gone undetected and could have contributed to the death of the children.
Agamba nti wadde bagamba nti omutwe gwe gwali gukola bulungi naye wayinza okubaawo ebintu ebirala bye bataalaba okulaga nti biyinza okuba nga ebyamuviirako okutta abaana abo.
He said he was not mentally okay, and he also denied being foul-minded in the killing of the children.
Agamba nti omutwe gwe gwali tegukola bulungi era agamba nti si yeyagalira okutta abaana bano.
In respect to this, he referred to the book about war, which was part of the evidence of PW18, the digital analyst, who analyzed his flash disk and found that he had saved a book entitled The Art of War by Sun Tzu. The accused person stated that he saved that file long before, and it cannot be said to apply to the killing of the children.
Nti waliwo ekitabo omujulizi ow'okunnamukaaga olwoludda lwabiri yayogera omujulizi ow'okuminamunaana yayogera ku kitabo ky'olutalo era n'agamba nti eno yali yakiteeka ku flash ye n'agamba nti ekyo kitabo yali yakiteekako edda tekisobola kubeera nga kyekyaviirako okutta abaana bano.
He also denied being deliberate and with forethought while making reference to the prosecution evidence of PW18, which revealed that using his phone, the accused person had made Google searches on subjects including ISIS beheading and for schools that teach young children. He said that although these searches suggest that he did it deliberately, there were factors that forced him to conduct them.
Nti ye yagaana ekyokugamba nti abaana bano yabatta nga kigenderedde, n'agamba nti omujulizi ow'okuminamunaana yagamba nti yakozesa essimu ye okukebera ebikwatako ekitongole ekitema emitwe gy'abantu kibayita ISIS, ng'anoonyereza ku masomero g'abaana abato, n'agamba nti
he said that although these searches suggest that he did it deliberately, there were other factors that forced him to conduct those searches.
Nti wadde bagamba nti bino bino gy'anoonyerezaako ebyamuleetera okutta abaana abo, waliwo ebintu ebirala ebyamuleetera okutta abaana.
During his testimony, the accused person further stated that he was under the control of some people whom he occasionally called friends, and that they fell into 3 categories. He stated that between January and March 2026, he entered an especially distressing period because he was contending with some people who were surveilling him, making many demands of him, and threatening to kill him. They began demanding money, and he noticed that they had all the capabilities. As a result, he left the Bunga neighborhood where he was staying and began sleeping on the streets.
Nti omuwaalirwa yagamba nti bino byonna yabikola olw'ensonga nti waliwo abantu be yali ng'alaba engeri 3 be yanyonyerako, n'agamba nti wakati wa January n'omwezi ogwokusatu yali mu kiseera ky'okwenyamira era ng'agamba abantu abo bamusaba ng'ebintu bingi, ne bamusaba ssente, ne bamugamba nti bagenda kumutta era n'ava mu kitundu kye yali abeeramu n'agenda n'atandika okubeera ku luguudo.
He stated that because of this, he tried to end it some way and somehow, and according to him, he tried several things to bring the whole thing to an end, including fleeing the country, robbing a bank, and killing his brother's family. He then concluded by saying that those said people whose names he chose not to disclose to the court influenced his actions of the 2nd of April 2026. He concluded his testimony by inviting the court not to honor the charges for murder against him because there were some circumstances that forced him to act the way he did on 2nd April 2026, and this is the date of the unfortunate incident.
Nti yatuuka ekiseera ng'ayagala kubikomeekereza n'agezaako okwagala kuva mu ggwanga n'agezaako okubba bbanka era n'agezaako n'okutta famire ya muganda we n'agamba nti abantu abo batayogera mu kooti be bamuviirako okutta abaana abo oba bye byamuviirako ebyo ebyatuukawo nga 2 Ogwokuna 2026.
Okay, there is a burden and standard of proof. This is known. The prosecution bears the burden to prove all the ingredients of the offense, or in 4 counts, beyond reasonable doubt. And I will skip that and I go to the ingredients of the offense of murder. Section 171 of the Penal Code Act, Chapter 128, which defines the offense of murder, provides that any person who, with malice aforethought, causes the death of another person by an unlawful act or omission.
Through this program, I've met with many past presidents, CEOs of Fortune 500 companies, and many other great leaders. These experiences have enhanced my understanding of leadership and entrepreneurship, and I'm so excited of the things I'm going to do in Zimbabwe. What I've learned the most is that there's no limits to the things that we can do, and besides that, there have been so many other opportunities for me to learn and grow. This program has been so amazing in enhancing my opportunities. Even at the early stage of my journey, I plan to explore these opportunities further as I go back to my home country.
Waliwo okufa nti akufa okwo kwali kumenya amateeka nti ate okufa okwo nti yakukola yali alina ekigendererwa era abalina okuleeta obujulizi nga bulaga nti omuntu ali mu kooti yeyaza emisango gino.
I will discuss all the 4 counts together because they are supported by the same evidence. However, the third ingredient of the unlawful act being actuated by malice aforethought shall be addressed last.
Nti emisango gyonna ajja kugyogerako mulundi gumu okuggyako ekigendererwa kyagenda okwogerako kyokka nga kyawukanye n'ebiri.
And I will do it last.
Kyagenda okusembyayo.
Death of a human being or human beings. Death may be proved by production of a postmortem report or evidence of witnesses who state that they knew the deceased and attended the burial, also the dead body. And in the instant case, the fact that the infants Eteku, Gideon, Keisha, Ageno Roth, or Tim, Ignatia, Seriang, and Odeke Ryan are dead is not in dispute. And in proof of this, the prosecution adduced the evidence of Dr. Katongole Abdul, who performed the postmortem examinations on the bodies of the 4 children, and he confirmed that they were dead. The parents of these children, namely Apollo Stella is the mother of Eteku Gideon, Komakech Marvin is the father of Kisha, and Bazia Rollins is the father of Seriange, and Okrutu Simon is the father of Ryan Odeke. They all confirmed that their children died and they were buried.
Basobola okulabira ku baluwa omusawo gy'awandiika ng'amaze okukebera emirambo obujulizi bw'abantu abaali bamanyi abantu bano ate ne babaziika bagamba nti Eteku, Keisha, Seryange ne Odeke okufa kwabwe bona tebakuwakanya kubanga omusawo gwe bayita Katongole yakola lipooti ng'akakasa nti abaana bano baafa ate n'abazadde b'abaana bonna bajja ne bawa obujulizi ne bakakasa nti abaana bano baafa.
Also, the evidence of one of the caretakers, Miss Namtevi Phoebe, and the coordinator of the center, Miss Aneta Goye, who were the eyewitnesses to the attack on the children that resulted in their death, also confirmed that they are dead. And the prosecution also adduced the evidence of the divisional CID officer Kabalagala, called Esserite James. He testified as PW 15, and the scenes of crimes officer, he testified as PW 14. They testified that they saw the bodies of the 4 children.
Nti Phoebe ne Annette baaliwo nga balaba omuwawalirwa ng'asala abaana abo ne kibaviirako okufa, era bajja mu kkooti ne bakakasa nti abaana baali bafudde, era ne baleeta abajulizi ow'15, ow'14, ow'15 yakolera okunoonyereza emisango mu Kawaragala, ne baleeta n'eyagenda gye bakoledde emisango, era ne bakakasa nti bwe baatuuka mu kifo ekyo balaba abaana abo nga bafudde.
Having considered the evidence and in agreement with the joint opinion of the 3 assessors, I find that the prosecution has proved beyond reasonable doubt that the 4 infants, namely Eteku Gideon, Kisha Agenoroth Otim, Seriang Ignatius, and Odeke Ryan are dead.
Okusinziira ku bujulizi akaanyiza ne ba assessor bwe bagambye nga bagamba nti abaana bano Eteku, Keisha, Seriange ne Odeke baafa.
Also, the fact that the death was unlawful is also not disputed, given the account of the eyewitnesses to the offense and the nature of the injuries on the bodies of the 4 children.
Ekyokugamba nti oba baafa mu bumenyi bw'amateeka nakyo tebakiwakanya olw'ensonga nti waliwo obujulizi bwabo abaaliwo ne balaba ate n'ebiwundu abaana be baabasanga nabyo.
And having considered the evidence and in agreement with the joint opinion of the 3 assessors, I find that the prosecution has also proved this ingredient beyond reasonable doubt, that Eteku Gideon, Keisha Agenoroth Otim, Seriang Ignatius, and Odeke Ryan, their death was caused by an unlawful act.
N'olwekyo Oweekitiibwa Mulamuzi akaanyiza ne ba assessor bwe baamuwabula nga bagamba nti Eteku, Keisha, Seriange ne Odeke nti okufa kwabwe kwali kumenya amateeka, n'olwekyo obujulizi bumala okulaga nti mu butuufu abaana bano baafa mu bumenyi bw'amateeka.
The participation of the accused person, in order to prove participation, there should be credible, direct or circumstantial evidence placing the accused person at the scene of the crime as an active participant in the commission of the offense.
Ekyokulaga nti oba omuwawalirwa ali mu kkooti eyenza omusango balina okuleeta obujulizi obulaga nti omuntu ono yatta abantu bano obuliwo oba obujulizi obwetoolodde embeera ezaaliwo.
The instant case that the participation of the accused person is not contested, because the accused person himself did not deny having killed these children.
Omusango guno ekyokuba nga yatta abaana omuwawalirwa takiwakanisa.
I will proceed to also to look at the evidence that the prosecution produced to support the fact that it was the accused person who killed these 4 children. The offense occurred in broad daylight, specifically at 11 a.m. or thereabout. The accounts of the eyewitnesses to the crime, namely Miss Phoebe Namtevi and Miss Annette Odong Agoye, the caretaker and coordinator respectively, revealed that the accused person with whom they had just been interacting in the office of Mr. Nate was seen gruesomely and brutally cutting the 4 children with a sharp knife, which he threw out of the chain link fence upon seeing the first responders to the scene.
Kkooti egenda kutunula obujulizi era bwe bwali bwe baleeta naye n'agamba nti ebintu bino byaliwo emisana zaali ssaawa 5 ez'ekumakya ng'ate waliwo abajulizi abaaliwo ne balaba nga Phoebe ne Annette ng'abo n'abakolera essomero eryo. Ate ne bagamba nti omuwawuliro baali boogera naye era nga yali yakafuluma naye ne bamulaba nga asala abaana abo oluvannyuma n'asuula akambe wabweru w'eggeeti.
The prosecution further adduced the evidence of the scenes of crimes officer Mr. Mutaka Jim, his PW14, and SRH James, the lead investigator, PW15, who testified to the effect that they responded and went to the center, which they referred to as the primary scene, and they found that the accused person had already been arrested by the first responders and was being kept in the guardhouse to keep him away from the angry mob that wanted to lynch him. PW15 SRH James then rearrested him and took him to Kawalagala police station.
Nti waleeta omujulizi ow'okuminabana nga yagenda mu bifo gye bakizaamu emisango bamuyita Mutaka Jim, naye ne baleeta n'omujulizi owa15 oyo akolera ebyokunoonyereza emisango ku poliisi y'e Kawalagala, era nti badduka ne batuuka mu kifo ekyo. Bwe batuuka ne basanga omuwawaabirwa baali bamaze okumukwata nga bamuterese mu kayumba k'omukuumi nga bamutaasa ku bantu abaali baagala kumukuba, era oluvannyuma omujulizi owa 15 n'addamu n'amukwata n'amutwala ku poliisi.
The prosecution also adduced forensic evidence that implicates the accused person by placing him at the scene of the crime, namely evidence of AIP Odongo Emmanuel. He is a CCTV analyst, and he testified that police CCTV cameras on the roads and some private CCTV cameras showed that a motor vehicle RAV4 was seen being driven from Chanja, where the accused person was residing, through Napawa until it reached Renewal Circle in Ggaba, where it was captured by the private camera of Renewal Circle on 1st April 2026.
Era baleeta obujulizi obulala obw'abakakensa ne baleeta omuserikale gwe bayita AIP Odongo Emmanuel ng'ono yeekebeja zi CCTV kamera oba kamera ez'okukubo, era n'agamba nti mu kwekebeja yalaba emmotoka ekika kya RAV4 nga baagivuga kuva e Chanja n'ayita Nakawa ne batuuka ku Renewal Circle, era ne kamera yako Renewal Circle n'emukwata nga 1/4/2026.
And this court takes judicial notice that the Renewal Circle, which is part of the Ggaba Community Church Complex, is directly behind the center.
Ate kooti eraba nti Renewal Circle nayo eri kumpi ne kanisa ya Ggaba Community Church, ate eri kumpi n'essomero lino.
Upon parking the motor vehicle in the parking yard of Renewal Circle, the accused person was seen alighting from the vehicle and walking towards the center. This corroborates the evidence of PW6 Ms. Phoebe, who testified that the accused person had come to the center on the 1st of April 2026 and had approached the gate of the center on foot. The accused person remained at the gate from where he had a conversation with PW6 regarding the requirements for enrolling his child at the center.
Nti era bagamba nti bwe yapaakinga ku Renewal Circle yatambula n'agenda ku ssomero eryo, era kino kyongereza ku bujulizi bwa Phoebe eyagamba nti nga 1/2026 nga muwandibwa yatambuliza ebigere n'atuuka ku geeti era ne boogera wamu ng'amubuuza biki ebyali byetaagisa okuleeta omwana.
The CCTV analysis report also revealed the accused person being ridden on a border on the day of the incident, 2nd April 2026, at 10:16:13. That is 10 o'clock, 16 minutes after 10 and 13 seconds. And he was carrying a black backpack.
Nti era alipoota eyo eyazi kamera egamba nti omuwawaabirwa baamulaba ku lunaku olwo lwennyini ng'ali ku booda ng'azaali ssaawa 4:16 n'obusekenduzi 13 ng'ali yali yeetisse akasawo akaddugavu, akasawo ak'okumugongo.
While in court, the witness, who was PW13, played the footage and the images, which clearly confirmed the movement of the motor vehicle on the 1st of April 2026 and the border carrying the accused person on 2nd April 2026.
Era bwe baleeta ezikamera ezo ne baziraga kooti, oyo omujulizi ow'ekumi yaziteeta ne bakakasa engeri emmotoka ekika kya Ford yatambulamu nga lumu Ogwokuna 2026 era ne balaga ne boda bwe yatambula ng'emuleese nga 2 Ogwokuna 2026.
Whereas the defense counsel during his submissions claimed that the images were not clear, it is not true because the accused person could be clearly identified when he alighted the vehicle at Renewal Circle on 1st April 2026 and also while on a border on 2nd of April 2026.
Nti oludda olwawabiri w'abalooya bagamba nti ebifaananyi byali tebirabika bulungi naye baali batuufu kubanga baamulaba bulungi ne bamwetegereza bwe yapaakinga ku Renewal Circle nga lumu Ogwokuna 2026 era ne baddamu ne bamulaba ng'ali ku booda nga 2 Ogwokuna 2026.
The prosecution had earlier on adduced the evidence of PW8 is called Hashim Juma, one of the directors of Trip Car Rental Uganda, who testified that the motor vehicle belongs to his company and the accused had hired it from him to be used on the 1st and 2nd of April 2026 on self-drive.
Nti baleeta omujulizi ow'omunaana nga bamuyita Hashim Juma, ono yali yapangisa omuwaabirwa emmotoka ekika kya RAV4 yali yakozesebwa nga lumu n'ennaku z'omwezi 2 Ogwokuna 2026 nga yali agenda gyevugira.
However, the accused person used the motor vehicle only on 1st April 2026 because it got mechanical defects. This testimony was corroborated by the CCTV evidence where the accused person was seen in the footage of 1st April 2026 pushing the vehicle at Shell Kitgum House, Ginger Road at 2 p.m. with the assistance of the staff of Shell.
Nti emmotoka yagikozesa nga lumu Ogwokuna 2026 wokka kubanga yamala n'efuna ebizibu era kino kyongerezebwako obujulizi omwaleeta obujulizi bwa kamera ng'agamba bamulaba ng'asindika eno emmotoka ku Shell Kitgum House Ginger Road zaali ssaawa 8 ez'emisana nga bakola ku Shell bwe bamuyambako okugisindika.
The accused had earlier on called Hashim and told him about the faulty car, and Hashim had advised him to park it at Shell Kitgum House.
Nti yali yakubidde Hashim n'amugamba nti emmotoka yali efunye obuzibu era n'amugamba nti agipaakinge ku Shell ya Kitgum House.
In the footage of 2nd April 2026, the accused could be easily identified putting on a checkered black, white and grey shirt and black sunglasses when he was on a border.
Nti ku katambi ke baleeta ng'akaali ka 2 Ogwokuna 2026 omuwawaabirwa baamulaba bulungi ne bamutegeera kubanga yali ayambadde yali ayambadde esaati y'ebikuubo ate nga yali ayambadde ne gaalubindi.
And this is corroborated by the evidence of the SOCO, that is the scenes of crimes officer, and the investigator who recovered the said sunglasses stained with blood at the primary scene and took the said shirt from the accused person upon his arrest and submitted both items for the DNA analysis.
Kino kyowereza ku bujulizi bw'oyo omupoliisi agenda mu kufunibanyizaamu emisango kubanga bwe yatuuka mu kifo ekyo n'asanga gaalubindi ezaaliko omusaayi n'azigyayo era n'amugyako n'esaati eyo n'abisindika mu beekereja ebintu ebyo.
The DNA analysis revealed that the cuttings from the shirt contained the DNA of the accused person, while the sunglasses, which were stained with blood, had mixed DNA of both the accused person and of Keisha again Roth, whose body had been labeled as body 39 by the scenes of crimes officer.
Nti Nyandaga Butonde bwe baakebera essaati gye bajja ku muvunaanibwa baagikebera nga yaliko nga Keisha omwambo gwe baali bagutaddeko namba 39.
Prosecution also adduced evidence that the accused person was cutting the children with a knife, which he threw over the chain link fence upon seeing the first responders at the scene. The knife was recovered by the scenes of crimes officer. It was a kitchen knife with a silver handle and black blade with the label reading Ming Feng. And while at the laboratory, a swab from the knife handle was taken, and also a swab from the blade was taken. And it was established that the handle had a male DNA profile which belonged to the accused person.
Nti obujulizi bwonna bugamba nti yali abaana bano nga basaza akambe era abantu bwe batandika okujja akambe n'akasuula wabweru wa geeti kakambe kano kaliko ebigambo Ming nti bwe baamala kamba ako ne bakatwala kukeekereja bwe baamala okukeekereja ne basanga nga waliwo endagala butonde ez'omuwawaabirwa.
Also, the blood stains on the blade of the knife were for body 3 and body 37. And body 3 was for Odeke Ryan, while body 37 was for Seriange Ignatius.
Nti era ne akambe bajjako omusaayi gwaliko ne bagenda kukeekereja ne basangako endagamutonde za Ryan ne Seriange.
Whereas the accused in his defense did not deny the killings of the children, the defense, this defense would be discussed at length while discussing the last ingredient.
Nti wadde mwawulira teyeegaana ekyokutta abaana abo naye ensonga eyo gye yawaayo oweekitiibwa mulamuzi agenda kugyogerako.
During the submissions of counsel for the accused person attempted to suggest that the accused person was not adequately implicated for the offense, and his argument was based on the fact that whereas PW6 and PW7 testified that they were first responders, namely Cyrus and Moses, who are said to have apprehended the accused person, and kept him in the guardhouse. None of those first responders was called as a witness. And he wondered where exactly the police found the accused person to arrest him.
Nti abalawuya nga babumbawumba tebabaleeta mu kooti naye neyeebuuza poliisi yamusangawa okumukwata.
I note that whereas it was prudent to have one of those witnesses to come to court, failure to have them did not affect the prosecution evidence. At least PW6 and PW7, that is Phoebe and Annette, testified that they saw the accused person being apprehended and being kept in the guardhouse, and PW15 and PW14, that is the investigator, the lead investigator, and the SOCO, the scenes of crimes officer, they confirmed finding the accused person having been arrested and kept in the guardhouse. That evidence was not challenged at all in cross-examination, and in light of all the other evidence placing the accused person at the primary scene of crime, it is my finding that the accused, that the evidence that the accused was apprehended in the act of slaughtering the children, kept in the guardhouse and later picked up by police is true.
Nti era bagamba omusibe omulamuzi agamba kituufu abano abantu abasooka okujja bandize mu kooti ne bawa obujulizi naye ne balaba nga tebaze kubanga Phoebe ne Annette bajja ne bawa obujulizi ne bagamba nti baliwo era ne balaba nti bamukwata ne bamutereka mu kayumba k'omukuumi era waliwo obujulizi ebirala b'embiri n'okumi na bataano era bajja ne bagamba nti basanga nga omwawabira bamaze okumukwata ne bamutereka mu kayumba k'omukuumi n'olwekyo okusinziira ku bujulizi oweekitiibwa omulamuzi agamba kituufu omwawirwa bamukwatira awo ng'akola omusango ogwo era ne bamukwata ne bamutereka mu kayumba k'omukuumi.
In light of the above, it is the finding of this court and in agreement with the joint opinion of the assessors that the prosecution has proved beyond reasonable doubt that the accused person caused the death of the 4 children, namely Eteku Gideon, Keisha Agenrofo Tim, Seriange Ignatius, and Odeke Ryan.
N'olwekyo oweekitiibwa omulamuzi akkiriza ne ba assessor bamuwabula agamba nti oludda lwabi luleese obujulizi obumala okulaga nti mu butuufu abaana bano Eteku, Keisha, Seriange ne Odeke baafa.
I will go to the last ingredient, and that is the ingredient of malice aforethought.
Kati agenda kwogera ku ky'okugamba nti eyata abaana bano yali alina ekigendererwa.
Malice aforethought is defined in section 174 of the Penal Code Act. And the summary of it is that malice aforethought shall be deemed to be established by evidence provided for by the following circumstances: an intention to cause the death of any person, whether that person is the person actually killed or not; B, knowledge that the act or omission causing death will probably cause the death of some person, whether that person is the person actually killed or not, although the knowledge is accompanied by indifference whether death is caused or not, or by a wish that it may not be caused. In summary, that you must have had an intention to kill somebody, or you had knowledge that your acts or your failure to act would actually result into the death of a person.
Ekigendererwa ekitabo ky'ebibonerezo akawayiro 174 naye kigamba nti obujulizi bulina okulaga nti waliwo ekigendererwa okutta omuntu ne bw'oba nga ogose sikuwayo oyagala kutta, olina okubeera ng'omanyi nti bino byonna by'oli mu kukola biyinza okuviirako okufa kw'omuntu. Ekikulu kiri nti olina okuba ng'omanyi nti byonna by'ogenda okukola biyinza okuviirako omuntu okufa.
So malice aforethought is a mental element, and it is not easy to prove with direct evidence. But inferences may be made from a number of things, including the nature of the weapon used, the part of the body targeted, the nature of injuries, and the conduct of the accused person before, during, and after the commission of the offense.
Ekigendererwa kibeera mu mutwe gw'omuntu, n'olwekyo kiba kizibu nnyo okuleeta obujulizi okukiraga, naye basobola kukirabira ku bintu bingi. Ekisooka basobola kulabira ku kisi ekikozesebwa, basobola kulabira ku kitundu eky'omubiri kye bakozesa, era basobola kulabira ku birundu obuvume omuntu bw'afunye, ate basobola okulabira ku nneeyisa y'omuwawaabirwa mu kukola ekintu ekyo ng'akikoze oba nga tannakikola.
Prior planning or prior threats of the accused may be used to infer malice aforethought.
Omuntu okusooka kuteekateeka ekintu basobola okukiraba ne bagamba nti yali alina ekigendererwa.
To prove this ingredient, the prosecution adduced evidence from eyewitnesses to the offense, that is Phoebe and Annette, who testified that they saw the accused person aggressively and gruesomely cut the necks of the 4 children with a knife.
Nti oludda lwabi lwaleeta obujulizi bw'abantu abaaliwo nga Annette ne Phoebe, era bajja ne bagamba nti baalaba omuwaabirwa ng'asala bubi nnyo ensingo z'abaana bano.
This evidence was corroborated by the findings of the post-mortem examinations of the 4 children's bodies and by the testimony of Dr. Katongole Abdul, who examined all of them and described the injuries on the deceased as follows.
Era ekyo kyongereza ku bujulizi za postmortem reports oba ebbaluwa ripooti omusawo bw'ayita katongole ze yawandiika ng'amaze kwekebejja emirambo gy'abaana bano n'anyomera ebiyinda abaana bye baafuna bwe tugenda okubyogera.
And I will go in the detail of the injuries for each of the deceased children. I begin with Eteku Gideon. He is said to have had a 14-centimeter long open wound on the right side of the neck, located at 66 centimeters from the right hem of the neck. The wound was longer than its depth, characterized by smooth edge, regular margins, no bridging fibers, marginal contusion, and the wound was deep, transecting through the esophagus, trachea, internal jugular vein, cut fractures, and the above descriptions were consistent with deep cut wounds.
Tusooka ne Eteku Gideon yalina ekiwundu obugazi nga kyali kya sentimita 14 ate nga kyali ku bulago saidi yabyo nga kyali kiwanvu nnyo nga kifumitira ddala ne ekyonoona ebitundu ebisinga ebyobulago era nga kiraga nti baamusala nnyo.
Keisha Ageno wrote a team was said to have a 9-centimeter long open wound on the right side of the neck at 67 centimeters from the right hem and 1 centimeter from the anterior midline, and the wound was longer than it was deep.
Nti Keisha naye yali alina ekiwundu nga kyali kya bugazi sentimita 9 ng'ate nakyo kyali ku bulago saidi yadyo. Nti kyali kiwanvu nnyo.
The wound was big, transecting through the skin, underlying neck muscles, the trachea, esophagus, major neck vessels, and nerves.
Ekiwundu kyali kiwanvu nnyo nga kiyita mu mubiri ne kisala emisuwa egisinga egy'obulago.
And he concluded, or he noted, that these findings were consistent with deep cut wounds.
Era n'agamba nti ebiwundu ebyo byaliwo olw'ensonga nti baamufumita nnyo.
Seriang Ignatius was said to have had a 14-centimeter long open wound on the right side of the neck, which was longer than it was deep.
Seriange naye yali alina ekiwundu nga kyali kya sentimita 14 ate nga bali bamusaze nnyo.
The wound was deep, transecting through the skin and underlying neck muscles, injuring the internal jugular vein.
Nti ekiwundu kyali kiwanvu nga kisala ne kiyingira ne kisayira ddala emisuwa gy'obulago.
He found that the above descriptions were consistent with deep cut injuries.
Era n'agamba nti ekiwundu kino kyajja olw'ensonga nti baamusala nnyo n'afuna obuvune.
This one also had another 4-centimeter long cut wound located on the right submandibular region. We go to Odeke Ryan, the last child. This one was said to have had a 9-centimeter long deep cut wound located on the right side of the neck. It was a deep cut wound dissecting through the underlying neck muscles, neck vessels, trachea, esophagus, and transection of a spinal cord. The cause of death for all the children was established to be hypovolemic shock due to cut wounds to the neck.
Odeke naye yali alina ekiwundu nga kyali kya sentimita 9 nga kirina ku kkono n'obulago ekiwundu kino kyali kiwanvu nnyo nga kisalira ddala emisuwa egisinga egy'obulago nga kigendera ddala ku nkizi n'agamba nti kyaviirako omwana ono kufa baamusala nnyo n'avaamu omusaayi mungi.
All the postmortem reports for the 4 children were admitted and marked as exhibits 1, 2, 3, and 4 respectively.
Alipoota z'omusawo zeyakeererako abaana bano banne zonna baazireeta mu kooti ng'ebizibiti ekisooka, ekyokubiri, ekyokusatu n'ekyokuna.
This evidence is further corroborated by the evidence of the scene of crimes officer, Mr. Mutaka Jim, who visited the primary scene of crime. This is the center. Immediately after the commission of the crime, he processed it and made a report which was admitted as PEX-10. And this is what he said, that at the center, he found the body of an infant on the veranda, and it was identified to him as that of Odeke Reyan. And he uniquely marked that body as 3. On this body, he observed one deep cut injury on the right side of the neck, with cuttings through the neck bones and muscles. And he took pictures of this body, and they are in his report on page 11 and 12.
Kino kyongerezebwako obujulizi bwa soko oba omupoliisi agenda mu bifo byebayizzaamu omusango bamuyita Mutaka Jimmy, era yagamba nti yagirawo mu kifo ekyo n'awandiika alipoota gye baleetanga ekizibito ekyo10. N'agamba bwe yatuuka mu kifo ekyo yasanga omwana omuto, omulambo gw'omwana omuto eyali ku kabalaza abali bamuyita Ryan, n'aguteekako namba 3. N'agamba nti omulambo guno gwali gulina ekiwundu ekinene ku bulago, ng'ekiwundu kino kyali kisala amagumba n'emisuwa egy'obulago, era n'akuba ebifaananyi n'abiteekamu alipoota eyo.
Shortly thereafter, he went to Wenzi Medical Center, this is the secondary scene, where he found the bodies of the 3 children, and they were identified to him as Eteku Gideon, and he uniquely labeled his body number 32, Seriang Ignatius number 37, and Keisha Ageno Roto team was labeled 39.
Omupoliisi oyo yayongera n'agenda ku Wenzi Medical Center, bwe yatuukayo ne bamulagayo emirambo gy'abaana abasatu, Eteku n'amuteekako namba 32, Seriyange n'amuteekako namba 37, Keisha n'amuteekako namba 39.
PRV 14, this is the scenes of crimes officer, further testified that all presented similar fresh injuries of deep cuts on the right side of the neck, which went through the muscles and bones.
N'agamba nti abaana bano baali balina ebiwundu nga byagala kufaanagana, nga bano baali balina ebiwundu mu mulago ku ddyo, ate ng'ebiwundu bino byali bisalira ddala nga bisala n'amagumba n'emisuwa y'obulago.
This court also observed the photographs of the bodies of the 4 infants and confirmed the gruesomeness of the attack on all of them, as evidenced by the nature of the injuries.
Era kooti yatunuulira ebifaananyi by'abaana abo n'ekakasa engeri abaana gye baafaamu baafa bubi.
The murder weapon, which is a knife, which caused those grave and fatal injuries on the children, was also recovered at the primary scene of crime just behind the chain link fence after being thrown by the accused person, and it was also admitted as evidence.
Nti era n'ekisi akambe baakafuna nga baali baakasuula wabweru ya geeti ne bakaleeta mu kooti ng'ekizibiti.
So we have those grave injuries and the knife that caused them.
Tulina ebiwundu ebyali ebiri ennyo n'akambe akaakozesebwa.
The above evidence would be sufficient to prove malice aforethought, because there would be no other inference that a person pounces on defenseless innocent babies and goes ahead to cut their necks as if slaughtering a goat or a chicken in that accurate and precise manner, other than that of malice aforethought.
Nti era ku bujulizi obwo bulina okuba nga bumala kubanga omuntu tasobola kugenda n'akwata obwana obuto nga tebusobola n'abusala obulago ng'asala embuzi oba enkoko.
However, the defense heavily contested this ingredient and insisted that the accused person was not in a right state of mind to form an intention to commit the offense of murder.
Nti oludda olwawabirwa bati ebyo si bituufu kubanga nti omwawabirwa omutwe gwe gwali tegukola bulungi n'olwekyo yali tasobola kutemula.
The accused person in his unsworn statement stated that he did not act intentionally or deliberately, and although there were claims that he was completely mentally okay, there may have been other mental challenges that may have gone undetected, which could have contributed to the death of the children. He insisted he was not mentally okay.
Nti bwe yali ayowoozaako teyalayira naye n'agamba nti ye kino teyakikola mu bugenderere, n'agamba wadde nti bagamba nti omutwe gwe gwali gukola bulungi naye bayinza okubawo ebintu ebirala bye bataategeera ebiyinza okuba nga byamuviirako okukola ebyo bye yakola, n'akkakkatizza ensonga egamba nti ye omutwe gwe tegukola bulungi. Omutwe gwe gwali tegukola bulungi.
The accused also denied being fair-minded in the killing of the children and
nenyerezako ebiseera by'emabegannyo tebiyinza okuba nga bye byamuviirako okutta abaana abo.
He also denied being deliberate and with forethought while making reference to the evidence of the Google searches that he made using his phone, specifically the search for ISIS beheading and for schools that teach young children. And he said that whereas these searches may suggest that he did it deliberately, there were other factors forcing him to make those searches, which factors he chose not to disclose to the court.
Nti era yagamba nti ye teyabikola mu bugenderere, yali akola olw'ensonga abantu bwe yali ayita mikwano gye ate nga baali bangeri busatu.
He also alluded to the fact that between January 2026 and March 2026, he entered into a distressing period because
nti yagamba nti wakati w'omwezi gwa January n'ogwokusatu 2026 yali mwenyamuvu nnyo olw'abantu bwe yali abaali bamusumbuwa era nga agamba abaali bamutambulirako era kyekyamuviirako okukola ebintu bino.
According to him, they began demanding for money, and he noticed that they had all the capabilities and they were following him closely. And as a result, he left the neighborhood of Bunga, where he was staying, and resorted to sleeping on the streets.
Nti baali bamusaba ssente era nga yalaba nga baali balina obusobozi nga bamugoberera nnyo, kyekyamuleetera kuva Bunga gye yali abeera n'agenda n'atandika kubeera ku luguudo.
The accused person stated that as a result of this, he tried to end it somewhere and somehow, so as to bring the whole thing to an end. And according to him, he tried to flee the country, tried to rob a bank, and tried to kill his brother's family. He then said that those people whom he at times referred to as his friends during his testimony had something to do with his actions of 2nd April 2026.
Nti yatuuka ekiseera n'ayagala okukikomiikiriza n'asalawo ave mu ggwanga n'agezaako okubba banka n'agezaako okutta famire ya muganda we n'agamba nti abantu abo be baali balina kye balina ku kyatuukawo nga 2/4/2026.
He invited the court not to honor the charges of murder because there were some circumstances that forced him to act the way he did on 2nd of April.
N'asaba kooti ereme okumusiimisa omusango gw'obutemu ng'agamba waliwo ensonga ezaamuleetera okukola bye yakola nga 2/4/2026.
Unfortunately, he neither stated the circumstances he claimed forced him to act that way, nor did he disclose the identities of his friends who may have compelled his actions on 2nd April 2026.
Ndebyendi teyayogera biki ebyamuleetera okukola ebintu ebyo bye yakola nga 2/4/2026.
No, he did not state the circumstances, and he also did not disclose the identities of those friends of his.
Nti ebintu ebyo byamuleetera okukola bye yakola ate n'amanya oba okwogera abaani abamuleetera okukola ebyo bye yakola 2/2026 teyabyogera eri kooti.
And because he made an unsworn statement in his defense, he could not be probed to give more information.
Olw'ensonga nti teyalayira ng'awa obujulizi bali tebasobola kumubuuza ebibuuzo bingi ku kino.
By the above claim, the accused raised a defense of insanity.
Olw'ekyo yagamba nti ye omutwe gwe gwali tegukola bulungi mu kaseera ako.
The defense of insanity is provided for under Section 11 of the Penal Code Act, Chapter 128.
Nti ekyokugamba nti omuntu omutwe guba tegukola bulungi ekitabo kya bibonerezo kikyogerako mu kawaliro ka 11.
And this is what it provides: that a person is not criminally responsible for an act or omission if at the time of doing the act or making the omission he or she is through any disease affecting his or her mind incapable of understanding what he or she is doing, or knowing that he or she ought not to do the act or omission, although his or her mind is affected by disease, if that disease does not in fact produce upon his or her mind one or other of the effects mentioned in this section in reference to that act or omission. I will summarize this to mean that the accused, somebody must show that he had a disease of the mind, and as a result of the disease of the mind, he was incapable of knowing the nature and quality of his actions at the time when that action is said to have been done. That's the summary of this law.
Nti etteeka lino mu bufunze ligamba nti omuntu alina okukakasa nti yali alina obulwadde bw'obwongo, nti ate okubeera n'obulwadde obwo nti yali tasobola kumanya ebikolwa bye yali akola kye bitegeeza oba kiyinza okumuviiramu bikolwa by'akoze.
So if it is found that actually he had a disease of mind, and that disease of mind made him incapable of understanding what he was doing and what its consequences would be, that would be a total defense to him.
Nti bw'agamba nti yali alina obulwadde bw'obwongo nga tasobola kutegeera biki ebyo yali akola, awo aba yeewozezaako.
And for the offense of insanity to stand, the accused person must satisfy the ground set out under the Magnaten rule, and the test is purely cognitive, and the defense must show whether the accused understood his or her actions or that his or her actions were wrong. The defense of insanity is twofold. First, that an insane defendant does not have control over his or her conduct, similar to somebody who is sleepwalking, not knowing what they're doing. And secondly, that the defendant does not have the ability to form a criminal intent. Without the ability to control conduct or the understanding that conduct is evil or wrong by society standards, an insane person or defendant presumably will commit crimes again and again. This person must not be in control of anything to do with himself. He cannot control his actions because of the disease of the mind. These rules require that the three tests should be proved. One, that an individual suffers from a defect of reason, which is caused by a disease of the mind, and that as a result, he or she does not know the nature and quality of normal. Like the accused person said that he was not mentally okay, then it becomes his responsibility to prove to the court that actually that was the condition that he was in at the time the offense was committed.
Nti omuntu okugamba nti omutwe gwe gwali tegukola bulungi alina okukakasa kooti nti yali tasobola kutegeera ebintu byali akola oba byali bituufu oba byali bikyamu oba byali si bikyamu, nti alina okulaga nti yali tamanyi biki byali bigenda mu maaso n'ebintu bye yali akola. Abeeramu omuntu atambula ekiro nga yeebase nga tategeera biki ebigenda mu maaso. N'agamba nti omuntu bw'atyo aba tasobola kubeera mu mutwe ng'ateekateeka ekintu okukola ekintu ekikyamu kubanga aba tasobola kumanya ekikyamu oba ekituufu. N'agamba nti aba tasobola kwesalirawo biki by'akola olw'ensonga nti alina obulwadde bw'obwongo.
The defense of insanity seeks to do away with an essential requirement of malice aforethought, and it seeks to prove that the accused person did not have the intention to cause death, neither did he have knowledge that such an act or omission would cause the death. And this is because of the presumption of sanity which is provided for in Section 10 of the Penal Code Act.
Nti okugamba nti omuntu omutwe gwe gwali gulina obulwadde baba baagala okuggyako kyokugamba nti omuntu yalina ekigendererwa okutta abantu naye
there is a presumption of sanity.
Naye waliwo amateeka agagoogera ku ky'omuntu okubeera nga omutwe gukola bulungi.
And it provides, in Section 10, it provides that every person is presumed to be of sound mind and to have been of sound mind at any time which comes in question until the contrary is proved.
Era etteeka kawaayiro ka 10 kagamba nti buli muntu yenna bamutwala nti omutwe gwe gukola bulungi oba talina obulwadde bw'obwongo okutuusa nga baweese obujulizi okulaga nti mu butuufu omuntu oyo akaseera ako omutwe gwe gwali tegukola bulungi.
This presumption of sanity puts the burden on anyone who claims insanity as a defense to prove that he or she was not in the right mental state at the time of the act or omission.
Nti kino kiraga nti omuntu agamba nti omutwe gwe gwali mulwadde oba nga alina obulwadde bw'obwongo alina okuleeta obujulizi okukakasa nti akaseera ako omutwe gwe gwali tegukola bulungi oba yali alina obulwadde bw'obwongo.
And I have already said that when anyone advances a defense of insanity, he bears the burden to prove it, though not on as a higher standard as the prosecution has to. Found in the judgment. Having laid down the above principles from the law and the decided cases, I will proceed to evaluate the evidence adduced by the accused person in a bid to prove the claim or the defense of insanity.
No,
I have said having laid down the above principles from the law and the decided cases on the defense of insanity.
Ostibo mulamuzi amaze okwogera ku mateeka agakwata ku ky'okugamba nti omuntu omutwe gwe amateeka n'emisango emirala egyayogerwako ku bulwadde bw'obwongo kati agenda kutunuulira obujulizi bwe baleeta obukwata ku bulwadde bw'obwongo.
I will need to establish whether the accused person was suffering from the disease of the mind at the time the offense was committed, whether that disease of the mind rendered him incapable of knowing the nature and quality of his actions, and whether he knew or did not know that what he was doing was wrong by reason of that disease of mind.
Kooti erina okutunuulira oba omuntu omuwawaabirwa yalina obulwadde bw'obwongo akaseera ako, ate alina okukakasa nti akaseera ako omuwawaabirwa yali tasobola kumanya nti bye yali akola byali bikyamu oba bituufu, ate alina okulaba oba yali amanyi nti byonna bye yali akola byali bikyamu oba bituufu.
As a result of the disease of the mind.
Olw'ensonga y'obulwadde bw'obwongo.
From the onset, I need to state that the accused person was the only one who testified that on 2nd April 2026, when he committed this heinous crime, he was not mentally okay.
Okuva omuwawaabirwa yeka eyawadde obujulizi okugamba nti ku lunaku olwo nga 2 Ogwokuna 2026 nti omutwe gwe gwali si mulungi tategeera bulungi.
As already indicated, he did not state what he was suffering from, apart from the claim that he was under immense stress from the period between January to March 2026 as a result of the people whom he occasionally referred to as his friends.
Teyayogera kiki ekyali kimuluma okuggyako okugamba nti wakati w'omwezi ogwa January okutuusa Ogwokusatu nti yali menyamuvu ng'alina abantu be yayogerako nti bali mikwano gye.
But like I already mentioned, he chose to conceal the identities of those people from court.
Naye yasalawo n'akweka amannya g'abantu abo n'atagabuulira kooti.
I will note at this point that I keenly observed the accused person as he gave his evidence, and I could see that he was withholding some information.
Nti era ng'awa obujulizi nga yeewozaako kooti yamutunuulira n'eraba nti waliwo ebintu bye yali akweka kooti.
Especially when it came to disclosing the names of those people.
Naddala okwogera ku mannya g'abantu abo be yayogerako.
Apart from this claim, there is no other evidence that was adduced by the accused person in a bid to prove the existence of the disease of the mind to avail him the defense of insanity.
Okuggyako ekyo tewali bujulizi bulala obwaleetebwa okulaga nti omuwawaabirwa yalina obulwadde bw'obwongo.
Counsel for the accused person vehemently argued that the prosecution failed to prove that on 2nd April 2026, when the offense was committed, the accused was not under the influence of mental illness.
Nti era ne bagamba nti olwali lwademererwa okuleeta obujulizi obulaga nti nga 2 Ogwokuna 2026 omuwawaabirwa yali ng'omutwe gwe gukola bulungi.
With all due respect, this argument was not legally backed and was misguided because when the accused person chose to raise insanity as his defense, the burden to prove that insanity shifted to him in light of the presumption of sanity under Section 10 of the Penal Code Act, Cap 128.
Nti omulooya wa muwawaabirwa yalindamu kubanga omuntu bw'agamba nti omutwe gwe tegukola bulungi yalina okuleeta obujulizi okulaga nti omutuufu omutwe gwe tegukola bulungi.
Counsel for the accused person further insisted that there was evidence on record from the prosecution provided by Dr. Nwamanya Emmanuel, who testifies as witness number 11. He's a police surgeon and is also a psychiatrist who examined the accused person on the 7th of April 2026, showing that the accused person has ever been admitted to Tarika Mental Hospital. That was his argument. He insisted that prosecution witness said that the accused person had ever been to Tarika.
N'alinaako n'agamba nti obujulizi baali babulese mu kkooti ng'omusawo gwe bayita Ggaba Emmanuel yakebera mu bawalira nga 7 gw'okuna 2026 ate n'agamba nti yali abaddeko mu ddwaliro ezitabika.
Regarding this evidence, I will need to provide context so it is not used to mislead the court. The evidence of PW11 as contained in PF24 and in his oral testimony in court is that he examined the accused person on 7th April 2026 and on his psychiatric and mental assessment of the accused person, he found the following, and I will quote verbatim. He had normal behavior, calm, cooperative, speech was coherent, his memory intact, and he exhibited good judgment. His thought process and content was normal, but believed in wealth by human sacrifice. He was able to explain the reason for killing the children as fortune hunting or enrichment. He got the idea on recalling childhood folk tales of getting wealth by sacrificing people.
Omujulizi ow'okumi yawandika alipoota mu kizibiti kye bayita mu kooti n'obujulizi bwe n'agamba nti omuwalirwa yamukebera nga 7 gw'okuna 2026 era bwe yali amwekebejja obwongo yagamba nga bwe yawandiika nti yali yeesa bulungi yamukkakamu ng'akwataganya naye bulungi n'ayogera bulungi ng'ajjukira bulungi byonna byeyayogera n'agamba nti ate yali asobola nakusalawo mulungi n'agamba nti naye yali akkiriza nnyo n'ebyokusaddaaka n'agamba nti ensonga lwaki yatta abaana abo yali anoonya bugagga n'agamba nti ekyo yakijja mu mbeerezi bamugambanga ng'akyali muto.
In that report, Dr. Nwamanya made the following note as information from the accused during the assessment, and I'm also quoting it verbatim. He had a history of past mental illness, treated between 2016 to 2025 for schizophrenia associated with both auditory and visual hallucinations. He killed his 2 to 3-year-old brother in 2016 or 2017, reportedly to save him from the troubles of this world. He also attempted suicide in 2023, and he was also a sickle cell patient on treatment. The findings above are suggestive of a mental condition with the psychotic episode. Further mental assessment is necessary since no medical documents were availed and he was the only source of information.
Era n'agamba nti omuwalirwa yamugamba nti eddako yali mulwadde w'omutwe era ne bamujjanjaba nga wakati wa 2016 kutuuka 2025 yalina obulwadde bw'obwongo nga ye asobola kulaba n'okuwulira ebintu abalala bye batalaba. N'agamba nti yatta muganda we nga 2017 nga yagala kwewonya ebizibu by'ensi. N'agamba nti n'agezaako okwetta nga 2023 n'agamba nti yali mulwadde wa nalubiri oba sikose. N'agamba nti naye baali beetaagisa okuddamu okumukebera olw'ensonga nti yali talina biwandiiko ebikakasa nti yali alina obulwadde bw'obwongo.
From the above, the word Butabika is not mentioned anywhere besides the accused person, as he gave his evidence, never at all mentioned having ever been admitted in Butabika mental hospital.
Nti mu byonna musawo bye yawandiika teyawandiikamu kigambo Butabika, ate n'omwawalirwa nga yeewozaako teyayogerako nti yali bali bamutaddeko mu ddwaliro Butabika.
It is important to note that the only witness in the entire trial who made mention of Butabika was DW2, whose identity has been concealed for his protection, but he's a biological elder brother to the accused person.
Nti omujulizi ayogera ku Butabika ye mujulizi yali wamuwalirwa ow'okubiri
The only witness.
Omujulizi yekka eyayogera ku ky'Obutabika ye mujulizi w'okubiri ow'awalirwa nga n'amannya ge baagakweka olw'ebyokwerinda bye era nga yali mukulu we.
He testified that in January 2022, he learned that the accused person was in a Butabika mental hospital, and when he went to inquire about the reasons for his admission there, he was informed by the in charge of the hospital that the case under which he was admitted in the facility was very sensitive and declined to avail any information.
N'agamba nti mu January 2022 yawulira
2020 January 2020
nti mu January 2022 yawulira nti muganda we yali mudongo ebutabika era agendayo bwe yagezaako okubuuza kikyali ebyali bikwata ku muganda we ne bamugamba nti ebyo tebasobola kubyogerako era tebaali tebasobola kumuwa byonna ebikwata ku muntu oyo.
Case under which he was admitted was very sensitive.
Yagamba nti omusango oba engeri gye bamuleese mu ddwaliro eryo yali tebasobola kubyogerako.
He further stated during cross-examination that he left without knowing why the accused person had been admitted in Butabika, despite having disclosed to the in-charge that the accused was his young brother.
Nti era yagamba nti yatuuka okuva ebutabika nga tamanyi kyekyali kikwata ku muganda we wadde nga yali amaze okubagamba nti yali mukulu we.
However, during the cross-examination of DW2, that is the brother of the accused person, the prosecution had an explanation for the accused admission in Butabika at that time, which they put to the witness. And according to them, the accused had murdered his young half-brother called Freeman, and to escape criminal culpability, he was taken to Butabika Mental Hospital to disguise as if he killed the child due to mental illness. And from there, he was whisked to the United States of America, where he stayed until sometime in 2025, when he returned to Uganda.
Nti abadda olwadi baali babuuza omujulizi w'omuwadi wa owokubiri bamubuuze nga bamugamba nti yali Butabika olw'ensonga nti yali asse muganda we gwe bayita Freeman era ne bamutwala Butabika nga bagamba nti omutwe gwe gwali tegukola bulungi. Bwe batuuka ebutabika ne bamugyayo ne bamutwala Amerika era bwe yajja Amerika n'abeerayo okutuusa 2025.
I find this proposition credible because if indeed the accused person had been admitted because of a medical condition, there would have been no justification for concealing that from his own brother. Besides, they would not have informed him that the case under which the accused person was admitted was very sensitive.
Nti era ekyo kooti eraba nti kyo kyali kituufu kubanga engeri gye yali agenze ebutabika
It is credible. It can be believed.
Basobola okukkiriza kubanga bwe yagenda ebutabika baali terina nsonga yonna lwaki tebamugamba byali bikwata ku muganda we ate ne bamugamba nti omusango gwali gumuleeseza mu ddwaliro eryo byali tebasobola kubyogerako.
The accused person himself would have mentioned that he had never been admitted in Butabika, either to the police surgeon, Dr. Nwamanya, or to Dr. Roger Agenda, who testified as PW12 and he's a psychiatrist at CKR International Hospital, Kampala.
Tunamwawadde yali asobola kwogera nti yali agenzeko Butabika ng'agamba Nwamanya Emmanuel oba Agenda Roger wa IHK.
Agenda Roger examined the accused person on 30th December 2025 at the request of the accused person for a sanity assessment, but the accused person did not inform him that he had ever been to Butabika.
Nti Agenda Roger yakebera mawalira nga 3 ogw'Oktoba 2025 n'amukebera walina obulwadde bw'omutwe era yamukebera teyamugambako nti yali agenzeeko mu ddwaliro ly'e Butabika.
To the contrary, the accused person informed Dr. Agenda Roger that the consultation with him, which is 30th December, was his index of first consultation with a psychiatrist in his whole life, and I will discuss the evidence of Agenda in detail later.
Nti Bwongo.
I also need to observe that though DW2 is the biological brother of the accused person, though they are brothers, he testified that they don't closely relate and he had not seen the accused person in the last 5 years, but only saw him at Kabalagala police station after his arrest in respect of this case.
Era omujulizi wa okubiri omuwangirana yali muganda we naye bali kusina mukwano nnyo bali bamaze emyaka etaano nga tebeeraba yayaddamu okumulaba ku Kabalagala poliisi nga bamaze okumukwata.
He also did not testify to knowing the accused person to suffer from any mental illness.
Era teyayogera nti yali amanyibwa muganda we yali alina obulwadde bw'obwongo.
In the absence of any medical evidence to support the claim of insanity, this court would have expected at least evidence from a family member of the accused person to speak to his alleged mental.
Engeri gye waali nga tewali biwandiiko by'abasawo okukakasa nti yali alina obulwadde bw'obwongo, waakiri aba family oba b'ekika kye bandize ne bawa obujulizi nga boogera ku nsonga eyo ey'obulwadde bw'omutwe.
The brother of the accused person informed the court that he shares both parents with the accused person and they are both still alive and they live in Uganda.
Muganda we yagamba nti babazaala wamu abazadde bombi be bamu ate bakyaliwo babeera mu Uganda.
If it was true that indeed the accused person suffers from any disease of the mind, either his father or mother would have been eager to come to this court to relay that information with some evidence.
Nti singa kyali kituufu nti yali alina obulwadde bw'obwongo, waakiri taata we oba maama we yandize mu kooti n'ayogera ku nsonga eyo.
It is also important to note that the details of the witnesses who came to testify for the defense were furnished by the accused himself, but he chose not to call any of his parents as his witnesses, who would have been better placed to testify to the claim of insanity and or any other disease of the mind.
Nti abajulizi abajja omwawabirwa yagamba beyayagala naye teyasaba nti bamuyitire abazadde be ate nga bandize ne bannyonnyola ensonga eno ey'obulwadde bw'obwongo.
Considering the above, I would still proceed to pose this question. Supposing it was indeed true that the accused person has ever been in Butabika in 2020, as stated by his brother, of what relevance would it be in relation to this offense, which is alleged to have been committed on 2nd April 2026, given the legal principles regarding the defense of insanity, that the disease of the mind must be present at the time of the commission of the offense and must have prevented one from knowing what he or she is doing and that what she is doing is wrong.
Kooti yeebuuzizza nti singa kyali kituufu nti mu 2022 omwawalirwa yaliko mugayo ly'Obutabika, kikwataganira awamu omusango guno ogwaliwo nga 2/2026. Era n'adda mu mateeka n'agamba nti balina okulaga nti obulwadde obwo bwaliwo akaseera ke yakolera ekintu kino, ate nti mu kaseera ako yali tasobola kutegeera nti kyeyali akola kyali kikyamu oba si kikyamu.
It is my considered view that in the absence of any evidence that the accused person was suffering from the disease of the mind as at the time of commission of this offense, his being admitted in Butabika in 2020 would not be of any relevance to this case.
Olw'okubeera nti tewali bujulizi obulaga nti yali alina obulwadde bw'obwongo, ekyokugamba nti bali bamutadde mu ddwaliro e Butabika tekikwatagana n'omusango guno.
I also need to note that in regard to the issue surrounding the admission in Butabika, that shortly it happened, I need to note that in regard to the issue surrounding the admission in Butabika, shortly into the evidence of DW2, the brother of the accused person, when he mentioned the word Butabika, counsel for the accused person made an application seeking for the orders of this court to order some doctors from Butabika to come and confirm the accused person has ever been in Butabika, and also confirm that he is incapable, or to establish whether he was capable to follow the proceedings. But this was after he had given his defense.
Nti era n'atunuulira embeera ze bamutwaliramu mu ddwaliro e Butabika, era n'agamba nti omujulizi owokubiri ku lw'oludda lw'omuwabulirwa nti bweyogera ku kigambo Butabika olw'omuwabulirwa n'agambirawo nti bayite abasawo okuva Butabika okukakasa nti omuwabulirwa naye tasobola kugoberera ebyali bigenda mu kooti naye bye yabisaba ng'omuwabulirwa amaze okuwa obujulizi.
I did not find calling anyone from Butabika relevant to this case, and I declined to grant that prayer, and I made a detailed ruling which is on record.
Nti teyalaba bwetaavu okuyita omusawo okuva Butabika era yabuwandiika ku fayiro.
In a further bid to support the claim of being mentally unwell due to the distress said to have been between January and March 2026, the accused person testified that he abandoned his home in Bunga and started living on the streets. And to prove this defense, he adduced the evidence of BW3 whose identities were also withheld for his security. And he informed the court that he was 25 years old, living on the street, and he had seen the accused person only twice while he was in Chisenyi, together with 40 children, aged between 7 and 10 years, and then his age.
Nti omuwawalirwa yagamba nti yali mu kiseera eky'okwenyamira wakati wa January n'ogwokusatu 2026 nti kyamuleetera okuva gye yali abeera e Bunga n'atandika okubeera ku kkubo n'amala n'aleeta omujulizi owokusatu era amannya ge tetujja gwogera olw'ebyokwerinda bye. Yagamba nti yali wa myaka 25 egy'obukulu nga yali abeera ku luguudo, n'agamba nti yali alabyeko omuwabire emirundi 2 gyokka nga bali Kisenyi era nga yali alina abaana abalala 4 nga bali ba myaka wakati wa 7 ne 10, abamu nga bali mu myaka gye.
Okay, I'll summarize his evidence. He testified that he saw the accused went to Chisenyi, and when the street children saw him, they requested for some water to drink, and he offered them food, which he actually paid for. And as he was leaving, he requested the witness for his contact, and they shared contact numbers. And the next time, he came with water in a 10-liter jerrycan and gave it to the witness with the other children. That is the summary of his evidence.
Nti omujulizi ono yajja n'agamba nti omuwalirwa yajjako mu Kisenyi ne bamusaba amazzi g'okunywa, mu kifo ky'okubaawo amazzi g'okunywa n'abagulira emmere n'asasula. Yali avaawo n'asaba ennamba y'essimu y'omujulizi ono, n'agamba nti olwaddako yajja nga alina akadomola ka lita 10 kalimu amazzi n'agawa omujulizi ono n'abaana abalala.
And he told him that the reason he wanted his telephone contact is that whenever he would need the children, he would help him to gather the children.
N'amugamba nti ensonga lwaki yali ayagala ennamba ye y'essimu, yali ayagala nti bw'aba ayagala abaana onaamuyambeko okubakungaanyiza wamu.
Counsel for the accused person, while relying on the claim of being on the street, submitted and said that it is not possible for a normal person to leave their home and start living on the street. But this court finds that there was no evidence that actually the accused person has ever lived on the street. He only went twice to these children in Chisenyi.
Nti omuwalirwa yagamba nti tekisoboka omuntu omulamu okutandika okuva ewaka n'atandika okubeera kubo, naye obwekitiibwa Nyanzi agamba tewali bujulizi obulaga nti yali abeera ku kkubo wabula yagendayo emirundi ebiri ng'agenda kugulira bano abantu emmere.
Also, this court notes that there was also evidence that as at the time of his arrest, he was not on the street. He had a home in Chanja, as testified by the landlord called Joel Mackay. He testified as PW10.
Ate weba mukwatira yali abeera ekyanja ate n'omujulizi eyajja wano yali landlord we bamuyita Mackay, yali mujulizi wa 10.
In light of the above, the accused person failed to adduce any evidence to support this claim that he was not mentally okay on 2nd April 2026 when he gruesomely and brutally murdered the innocent infants.
Nti n'olwekyo omuwawaabirwa alemereddwa okuleeta obujulizi okukakasa nti omutwe gwe gwali tegukola bulungi oba nga yali obulwadde bw'obwongo nga 2 Ogwokuna 2026 lwe yatta abaana abato.
The other probable defense that would be available to the accused person given his from his testimony would be a defense of diminished responsibility, and this one is provided for under section 177(1) of the Penal Code Act.
Ekirala ekyandimulyange kyakugamba nti yali obwongo nga tasobola kutegeera bulungi bye yali akola.
And this one also, it is where a person is found guilty of murder or being a party to the murder of another, and the court is satisfied that the person was suffering from an abnormality of mind arising out of arrested or retarded development of mind. This relates to somebody who has a disease of the mind that has resulted into poor development of the mind, and that as a result of that it takes away the person's mental responsibility.
Nti omuntu bw'aba nga omusango ogw'obutemu gumufiina naye ne basanga nga omutwe yali alina obulwadde bw'obwongo ate ng'obulwadde bw'obwongo bwali tebusobola kumukkiriza kubeera ng'ategeera ebyali bigenda mu maaso.
Even with that, the law provides in subsection 2 that if you raise that as your defense, it is you to prove that you are suffering from an abnormality of the mind.
Era amateeka gagamba nti bw'ogamba nti obwongo bwe bwali tebukola bulungi oba ng'olina obulwadde bw'obwongo olina okuleeta obujulizi okukakasa nti kyaliwo.
Looking at the evidence that the accused person adduced, there is nowhere he's talking about a retardation of his mind. The only issue that the accused person suffers from and was talked about by many witnesses is sickle cell disease.
Nti kusinziira ku bujulizi omuwalwa bwe yaleeta teri kiraga nti yali alina obulwadde bw'obwongo, kule okuggyako balaga nti yali alina obulwadde bwa nnalubiri oba sickle cell.
And when Dr. Agenda was asked as to whether sickle cell anemia is not an underlying cause for